Hawley. This is one of those confirmation hearing exchanges where you can tell within the first few minutes that the senator isn't simply asking for background information. He has found a case in a nominee's record that he believes goes straight to a fundamental question. What happens when religious liberty comes into conflict with government power? And as we go through this, listen carefully to the distinction being made between defending a government policy as a lawyer and personally agreeing with that policy. That distinction becomes extremely important here. Welcome back to the Political Brief. Today we're looking at a heated Senate confirmation exchange involving religious liberty, COVID restrictions, protests, and the First Amendment. From a conservative perspective, this raises some serious questions about whether government treated religious Americans fairly during the pandemic, and whether a lawyer defending an unconstitutional policy should be held responsible for the policy itself. Watch this one closely, because the disagreement gets much deeper than it first appears. And if you enjoy these political breakdowns, make sure you subscribe, like the video, and leave your thoughts in the comments. Now, let's get into it.
Hawley.
Thank you, Mr. Chairman. Congratulations to all of the nominees. Judge Ali Khan, I think the last time you and I visited, it was before the Homeland Security Committee. And I asked you a number of questions there, you, including some for the record, you answered those, which I appreciated. One question that I ask you, and I ask every nominee actually on that committee and this one, is whether or not the nominee has ever litigated against a religious liberty claim. Usually the answer to that's no. In your case, you answered yes, and you listed 5 different cases over a period of years, actually, in which you have litigated against individuals or churches' religious liberty claims. So let's just talk about a few of those, if we could. Let's start with some of your work during COVID. Case you list here, Capitol Hill Baptist Church versus Bowser. Do you remember that case?
Yes, Senator.
You remember working on that case?
Yes, Senator.
This was a case involving the district's lockdown policies that shut down churches in the district. Is that correct?
It concerned litigation over provision of the lockdown policies. The policies restricted all types of activity in the district.
All types of activity in the district?
Yes, Senator.
Did it restrict mass protests in the district?
Well, it restricted activities that one normally expected, including work, going to stores. It also did include these provisions that were challenged concerning churches.
So it exempted unusual or unlikely activities that's in the statute, that's in the ordinance?
When the mayor was enacting these orders at the outset of the pandemic, I think she was trying to be as comprehensive as she could, and the order did restrict a number of daily activities of district residents.
But it exempted mass protests?
I don't believe it said anything one way or another.
Can you point me to the text where it exempted mass protests?
I don't believe it said anything one way or another.
Of course it didn't, because it didn't exempt mass protests, right? You know that.
I think it was silent on the issue because I don't believe it was contemplated by the mayor's office.
Ah, so you think that mass protests should be in a different category than religious observances? Is that your position?
I think if there were protests on the book, then the mayor might have thought about that when she was enacting the COVID-19 restrictions. But I think she was trying to protect public health.
So you think it's fine to say to religious people that they are prohibited from gathering outside, wearing a mask, socially distanced. They can't do it. But if you want to come and protest, defund the police, if you want to support that, that's fine. You can gather en masse, person to person, close up, thousands of people. That's okay. That discrimination's okay. That is your position?
Senator, that is not my position.
It was your position. It's what you argued.
I did not write these orders. What I said.
You defended it in court. And you just articulated to me what I take to be your position.
What I was doing in the Capitol Hill Baptist Church was defending the mayor, my client, against a constitutional challenge to one aspect of the COVID-19 restrictions. We understood that strict scrutiny applies.
How did that case go for you?
We lost that case.
Why?
It was found that the restrictions did not meet the standard of strict scrutiny.
Meaning they were unconstitutional.
Meaning that they did not survive strict scrutiny, and it's a matter of public record that the District of Columbia did not appeal that decision.
Why? Why were they struck down?
Excuse me, Senator?
Why were the restrictions that you defended struck down as discriminatory? Why were they?
Because they did not satisfy.
Why didn't they?
The court concluded that there were restrictions that were not neutral of general applicability.
Yeah. That's legalese. Why didn't they? Why didn't they on the facts? You know the facts. You were a good lawyer. Why'd you lose?
We lost because applying the strict scrutiny test, the court concluded that the restrictions were not narrowly tailored to serve a compelling governmental interest.
Because?
Senator.
Oh, come on, Judge. Don't make me do this. Do you want me to go through it for you? You lost because Mayor Bowser was going to mass protests herself personally with thousands of people celebrating them. By the way, which is fine. We have the First Amendment in the United States. I want to be clear. That is totally fine. You want to protest? Go for it. I think that's totally fine. That wasn't the problem here. At the same time she was doing that, she was prohibiting churches, religious people, from gathering socially distanced outside wearing masks. And the district court said, you can't do that. That's discrimination. You can't separate people out based on their ideological beliefs or their positions. You can't do that, right? Isn't that what the district court said?
The district court said that
do you agree with it?
Could not survive strict scrutiny.
For those reasons, right? Why are you fighting me on this? I can't figure this out.
I am not fighting you, Senator.
So yes, you agree. That's what the district court said.
That was what the district court concluded.
Do you think they got it right? The district court get it right?
The district court, we did not appeal that decision. I think that district court decision is consistent with rulings that we got from the Supreme Court clarifying the application of the religious test to COVID-19 restrictions in Tandon and the Brooklyn Archdiocese.
My time's almost expired, and I know other senators want to ask questions, so let me just very quickly here. Do you think it's wrong to discriminate on the basis of religious faith?
Absolutely, Senator.
Why did you argue that religious services, religious people pose a greater risk of infection than people gathered to argue for defunding the police?
I was representing my client. The mayor and consulting epidemiologists had issued orders that she thought were going to protect public health. It was my role to defend those as a
Why did you make that argument? That seems like a strange argument to me, that religious people are somehow, more infectious than folks who have other ideological positions? I don't get it.
My understanding was the nature of singing and other things epidemiologists thought could transmit COVID at a higher rate.
You didn't put any scientific evidence on the record for it?
Senator, those were fast-moving cases, and they weren't going to full briefing and full summary judgment with a record.
That's not what the district court said. The district court said that you engaged in, and your client engaged in, and you defended discrimination on the basis of religious belief, that you offered no scientific evidence for it, that you pressed these arguments over and over and over without any foundation. Frankly, I'm disappointed that you made those arguments. You can choose what arguments to make. I'm disappointed you made those arguments. I'm disappointed you persisted in defending them here today. And for that reason, among others, I will not support your nomination. Thank you, Mr. Chairman.
Senator Tillis.
The senator starts by explaining that he asks nominees a very specific question. Have you ever litigated against a religious liberty claim? Usually, according to him, the answer is no. But in this nominee's case, the answer was yes, and not just once. There were apparently several cases involving religious liberty claims over a number of years. So immediately, you know exactly where the senator is going. And frankly, I think it's reasonable to ask. If someone is being considered for an important position in the federal government, particularly a judicial position, the public deserves to understand how that person has approached constitutional rights in their previous legal career. But we also need to make an important distinction right at the beginning. A lawyer representing a government client isn't necessarily expressing their own personal beliefs. Lawyers are often required to defend their clients' positions, even when those positions are controversial, unpopular, or eventually rejected by a court. That's an important principle of our legal system. But here's where this particular exchange becomes fascinating, because the senator isn't merely asking, "Did you represent the government?" He's asking about the actual arguments that were made. And that's where the temperature starts rising. The case being discussed involved Capitol Hill Baptist Church and COVID-era restrictions in Washington, D.C. The restrictions placed limits on gatherings and other activities during the pandemic. And this is where the senator raises what I think is one of the most important questions of the entire hearing. Were religious gatherings restricted while mass protests were treated differently? Because if the government says that people cannot gather for religious worship because of public health concerns, but then allows thousands of people to gather in close proximity for political protests, you've got a constitutional question that cannot simply be brushed aside. And as a conservative, I think this deserves very serious attention. The First Amendment isn't some optional privilege that government gets to switch on and off whenever circumstances become difficult. It protects freedom of religion. It protects freedom of speech. It protects freedom of assembly. And those protections matter most when they're inconvenient. It's easy to defend constitutional rights when everyone agrees with the people exercising them. The real test comes when you disagree with those people. And That is precisely why this exchange caught my attention. The senator essentially asks, if people can gather to protest a political cause, why should religious Americans be prevented from gathering outside, wearing masks, and socially distancing to worship? That's a legitimate question. Now, the nominee's response is essentially that the restrictions were government policy and that his role was to defend his client. And legally speaking, that's an important answer. He wasn't the mayor. He didn't create the restrictions. He was representing the government. But the senator isn't satisfied with that distinction. And I can understand why. Because eventually, the conversation comes down to what arguments were actually presented in court. The nominee says that the government was attempting to protect public health. And obviously, COVID was a genuine public health crisis. We should not pretend otherwise. Governments had to make difficult decisions with incomplete information. There were enormous uncertainties. People were getting sick. Hospitals were under pressure. And officials were trying to figure out what restrictions could reduce transmission. So we need to be fair about the circumstances. But, and this is a very big but, emergency circumstances do not erase the Constitution. That is the principle conservatives should be particularly careful about defending. Because once you accept the idea that constitutional liberties can simply be suspended whenever government declares an emergency, you create an extremely dangerous precedent. Today it might be a pandemic. Tomorrow it could be something else. And suddenly the government has established a precedent for restricting fundamental rights whenever officials believe circumstances justify it. That's why the courts exist. That's why judicial review exists. And that's why strict scrutiny exists in cases involving certain fundamental rights. And according to the exchange, the government lost the case. The court concluded that the restrictions did not survive strict scrutiny. That is extremely important, because the senator repeatedly tries to get the nominee to explain exactly why. And eventually, the answer comes down to the restrictions not being narrowly tailored enough to satisfy the constitutional standard. In other words, the government may have had a legitimate public health objective, but having a legitimate objective isn't automatically enough. You still have to respect constitutional rights while pursuing that objective. And that's where I think conservatives have a strong argument. You can believe COVID was serious. You can believe governments had a responsibility to protect public health. And you can still believe that government officials went too far. Those positions aren't contradictory. In fact, that's one of the most important lessons from the pandemic. Government can have a legitimate goal and still use unconstitutional means to pursue it. And that's why I think the senator's questioning about the protests is so significant. Because if the government was truly applying restrictions equally, then the argument becomes considerably stronger. But if one type of gathering is treated as dangerous while another gathering is effectively tolerated because of its political nature, then you've got a serious problem. The government cannot say, your assembly is dangerous because we don't approve of what you're doing, but their assembly is acceptable because we agree with or tolerate their political message. That's not how the First Amendment is supposed to work. Religious freedom doesn't become less important because the government is dealing with a crisis. And religious people don't surrender their constitutional rights simply because they want to attend church. Now, I want to pause here because I think there's something the audience needs to understand. The senator gets visibly frustrated because the nominee repeatedly returns to the fact that he was representing the mayor. And again, that's a legitimate legal distinction. If you're a government lawyer, you're often tasked with defending government action. That's the job. A criminal defense attorney doesn't necessarily believe their client is innocent. A corporate lawyer doesn't necessarily agree with every decision made by the corporation. And a government attorney can be required to defend a policy without personally supporting it. So I wouldn't automatically say, you defended this policy, therefore you personally believe religious people should have fewer rights. That would be an unfair conclusion based solely on the exchange. But that's not really the only issue being raised. The senator is pushing him on the substance of the legal argument. What did you defend? Why did you defend it? What evidence supported it? And did the government's treatment of religious gatherings actually have a legitimate scientific basis? Those are different questions. And this is where the nominee's answer becomes especially interesting. He says that epidemiologists had concerns about things such as singing and other activities associated with worship. Okay, that is a reasonable public health concern to raise. But then the senator hits him with the question, where was the scientific evidence in the record? And the nominee acknowledges that these cases were moving quickly and didn't proceed through a full, extensive evidentiary process. Now again, let's be fair. The early pandemic was chaotic. Courts were dealing with emergency litigation. Officials were making decisions quickly. Scientists were still learning about the virus. So it would be unreasonable to judge every decision made in those circumstances as though officials had years of hindsight. But the constitutional question remains. If you're going to restrict someone's fundamental religious liberty, the government should have a serious evidentiary basis for doing so. And if that basis doesn't exist, then the government shouldn't be surprised when the courts intervene. This is where I think the senator makes his strongest point. He essentially says, you're telling religious people they cannot gather, even outdoors, even with masks and social distancing, while large political demonstrations can happen. And if that's actually how the policy operated, then conservatives should absolutely be concerned. Not because conservatives should receive special treatment, but because everyone deserves equal treatment. That's the point. If liberals want to protest, they should have the right to protest. If conservatives want to protest, they should have the right to protest. If Christians want to worship, they should have the right to worship. If Jews want to worship, they should have the right to worship. If Muslims want to worship, they should have the right to worship. Government shouldn't get to decide that one form of assembly is politically valuable while another is somehow expendable. That's not religious liberty. That's government deciding which citizens' rights matter more. And I think that's a principle worth defending regardless of your politics. Now, the exchange takes another turn when the senator asks directly whether the nominee believes it's wrong to discriminate based on religious faith. The nominee says yes, absolutely. And then the senator asks the obvious follow-up. If you believe that, why were you defending a policy that the court ultimately found unconstitutional? That's the tension at the center of this entire exchange. And it's a legitimate tension. The nominee can say, I was representing my client. The senator can respond, but you still chose the arguments you made. Both points can exist simultaneously. But as a conservative, I would emphasize something else. This shouldn't just be about one lawyer. It should be about the philosophy of government behind the policy. Because the bigger lesson here is that emergency powers need limits. We cannot allow the phrase public health to become a magic phrase that ends constitutional debate. Of course, public health matters. Of course, government has responsibilities during emergencies. But the Constitution still matters. And sometimes protecting liberty means accepting some degree of risk. That's uncomfortable. It's supposed to be. Freedom isn't valuable because it's convenient. Freedom is valuable because it places limits on government power. And that's particularly important when government officials are under pressure. During a crisis, people are naturally more willing to surrender freedoms in exchange for security. That's human nature. But the responsibility of constitutional government is to make sure temporary emergencies don't become permanent excuses for expanded state power. That's one of the reasons I'm skeptical whenever politicians say, we need to suspend this right just for now. History teaches us to be extremely careful with those words, because governments are very good at acquiring power. They're not always as good at giving it back. And there's another part of this that I think deserves attention. The First Amendment isn't there to protect only speech that the government likes. If it did, it wouldn't really be freedom of speech. The same principle applies to religious liberty. The government isn't supposed to decide which religious practices are worthy and which aren't. There can obviously be neutral rules that apply to everyone. If there's a genuine public health restriction, it can potentially apply to religious and secular activities alike. But when the government starts creating different categories based on the nature of someone's beliefs or activities, that's when constitutional alarm bells should start ringing. And that's exactly why the court's decision in this case matters. According to the exchange, the court found that the restrictions failed strict scrutiny and that the government's approach wasn't sufficiently narrowly tailored. The government didn't appeal. And that should tell us something. It doesn't necessarily tell us that the government lawyers personally supported discrimination, but it does tell us that the government's legal position failed in court and wasn't taken further through the appeals process. So when the senator says he's disappointed in the arguments that were made, I understand the frustration. But I would be cautious about turning that frustration into a blanket accusation against the nominee's personal beliefs. That's where political commentary sometimes goes too far. A confirmation hearing should scrutinize someone's record. Absolutely. It should ask difficult questions. Absolutely. But we should distinguish between defending a client and personally endorsing the client's position. At the same time, defending a government policy doesn't mean a lawyer is immune from scrutiny. If you're being considered for a major federal position, your legal judgment matters. The arguments you made matter. The cases you chose to pursue matter. Your understanding of constitutional rights matters. So I think the nominee has a legitimate explanation, but I also think the senator has legitimate concerns. And that's what makes this hearing interesting. This isn't as simple as one side good, one side bad. The real issue is what limits should exist on government power when fundamental liberties are involved. My answer, as a right-wing patriot, is simple. The Constitution comes first. Not the mayor, not the governor, not the president, not the bureaucrat, not the political party. The Constitution. And if government officials want to restrict a fundamental right during an emergency, they should have to meet an extremely high standard. Because once you give government permission to decide which constitutional rights are convenient and which ones aren't, you're heading down a dangerous road. And I think conservatives should remember that this principle works both ways. You don't defend the Constitution only when your side benefits. You defend it when your opponents benefit too. That's what makes the principle meaningful. If a liberal church wants to worship, defend its right to worship. If a conservative church wants to worship, defend its right to worship. If someone wants to protest something you find offensive, defend their right to protest. Because if we start saying, well, I don't like their message, so maybe they shouldn't have that right, then we're not defending liberty anymore. We're defending power. And I don't want to live in a country where government gets to decide which citizens deserve their constitutional freedoms. That's not America. And that's why this exchange matters. Because the real question isn't whether we like the politics of the people involved. The question is whether government treated citizens equally under the law. The pandemic tested almost every institution in this country. It tested hospitals. It tested schools. It tested businesses. It tested families. And it tested the Constitution. We should be willing to look back at those decisions honestly, not with the goal of relitigating every argument forever, but with the goal of learning. What worked? What didn't? Where did government overreach? Were restrictions justified? And most importantly, what should the rules be if another crisis happens? Because there will be another emergency someday. Maybe not another pandemic. Maybe something else. And when that happens, we need clear constitutional boundaries already established. We shouldn't wait until the crisis begins to figure out how much freedom Americans are allowed to keep. That's why I believe the senator was right to raise this issue. I don't necessarily agree with every implication he made about the nominee personally, because again, representing a client isn't identical to personally endorsing the client's policies. But the underlying issue of religious liberty deserves a very serious defense. And if the government cannot demonstrate that restrictions are neutral, justified, evidence-based, and narrowly tailored, then Americans have every right to challenge them. That's not rebellion. That's constitutional government. And frankly, that's what the founders intended. Government was never supposed to be all-powerful. It was created with limits. Those limits aren't suggestions. They're the entire point. So when I look at this exchange, I don't just see another confirmation hearing. I see a debate about what happens when government power collides with individual liberty. And I think the conservative answer should be crystal clear. Government has a responsibility to protect public safety. But government also has a responsibility to protect freedom. Those responsibilities have to coexist. You cannot protect the public by simply pretending constitutional rights don't exist. And you cannot defend liberty responsibly by pretending public health concerns don't exist. The challenge is finding the constitutional balance. But when religious Americans are singled out while other gatherings are treated differently, that balance becomes deeply questionable. And that's why I think this senator's questioning deserves attention. Not because we should automatically assume the nominee is anti-religious. Not because every government lawyer who defended a bad policy is personally guilty of supporting that policy, but because the legal arguments themselves deserve scrutiny. And the courts have already given us an important piece of the answer in this particular case. The restrictions didn't survive the constitutional test. That's the fact we should focus on. So now I want to hear from you. Was the senator right to press the nominee this aggressively over the religious liberty case? Do you believe the government crossed the line during COVID by treating religious gatherings differently from political protests? And here's the bigger question. When America faces another national emergency, how much power should government be allowed to exercise over individual constitutional rights? I think that's a conversation Americans need to have before the next crisis, not after. If you enjoyed this breakdown, make sure you hit the like button, subscribe to The Political Brief, and turn on notifications so you don't miss our next political reaction. And tell me what you think in the comments. Because regardless of whether you're Republican, Democrat, independent, religious, non-religious, conservative, liberal, or somewhere in between, there's one principle we should all be able to agree on. Your constitutional rights should not depend on whether the government approves of you. That's the whole point of having rights in the first place.